going to try to do today, I can't make you all IP lawyers in 20 minutes. I'm going to try to give you the information that I think you should have before you ever get to talking to a lawyer, so you can be thinking about these things as you're creating your startup. So when you do actually get in, just talking to a lawyer, you'll be in a lot better position, and you can avoid some of the troubles that other startups have had. So thanks again this Startup Weekend for having me. So what are we talking about here? You're all working on these things right now. A startup, a lot goes into it, right? It's a group of people, typically. We've got 9 groups here today, but a lot of things are going into it. Time, talent, energy, IP, and capital are all going into each of these startups. Different people are obviously contributing different levels of each of these, but typically you're going to be seeing all of the people contributing different combinations of this. So for those that don't know what IP is, I got another slide coming up, but be thinking patents, trademarks, copyrights, trade secrets, and I'll talk about what each of those are real briefly. So what's the problem here? To each of you that are working on a startup, in your mind you may be thinking about it a different way from the beginning. You're not always going to be on the same page. So a common scenario, you get one person who comes up with the idea. They're able to contribute time, talent, energy, IP. Maybe they don't have a lot of money. That's a common situation. And they perhaps have an idea how they think this company is going to be split up once it's up and running. So let's say they bring on a friend who can do some work for them, able to provide time, talent, energy, maybe no intellectual property, and maybe no capital themselves. So this person may have a different idea about how ownership of the company is going to be split up. An important thing here is when you're bringing on other folks, maybe this person works for another company, and you need to be careful about what intellectual property they may be bringing in from their other employer, and being careful to really draw a fine line between IP that's coming into the startup and IP owned by other entities. And then obviously a really common player is the investor, who maybe just comes in with dollar bills. And again, they may have a different idea of how this ownership is going to be split up. So the key is finding out what this person thinks, what this person thinks, what this person thinks, figuring that out at an early stage, getting that in writing in the form of maybe just a simple letter of intent, letter of understanding up front, and then obviously initially some more formal agreements once the time comes for that. So what is intellectual property? Broadest description, I can give you exclusive rights granted to a variety of intangible assets. So these aren't the hardware owned by your company. It's not the building your company's in. These are the ideas you're having. These are the company name, the product name. So copyright generally covers music, literary, and artistic works. For your purposes, that's going to be things like your software code, things like manuals you create letting people know how to use your product, advertisements that you may come up with would all be protected by copyright law. Trademark is going to protect words, phrases, symbol, and designs. For you guys, think your product name, company name, your logo, all those things will be protected by trademark law. And then patent protects discoveries, inventions. So by and large for you guys, that's going to be whatever your technology might be, and then if you have any novel business methods or something along those lines, to be able to protect those with patents. I mentioned trade secrets. Trade secrets are important too. That's how you're going to be able to protect a lot of the information you're coming up with before you share it out to the world. In fact, that's a requirement of a trade secret, is that it's kept secret and only known by those who need to know it. So the important thing to know here is that copyright automatically defaults to the author. It's not going to automatically default to the startup. Similar with a patent, that's typically going to default to the inventor. So you're going to need some sort of agreements in place to make sure that that intellectual property is appropriately transferred to the startup, preferably at the very beginning and not later once the IP becomes terribly valuable and then you get into an argument over who owns what or who contributed what. Typically that can be done via a simple transfer and assumption agreement, and that's usually right at the early stage in consideration for equity. That's what those people we mentioned earlier are receiving in exchange for giving their IP. They're getting that equity in the company. If you're a startup where funding is uncertain, maybe very early stage, and you don't necessarily know where this is going, sometimes founders will use an irrevocable license that's based on milestones. So what that'll do is you'll say, yeah, I'm giving the IP to the company so long as these certain milestones are met. If those milestones aren't met, and they can be things like funding milestones or deliverables, if those aren't met, the IP would then revert back to that founder and he can take it and go do something else with it. So that's a mechanism for startups that still not sure where they're headed. And then importantly, I mentioned if you're bringing in people that have other jobs or other employers or work for another startup, make sure to explicitly, in writing, exclude whatever non-company IP may exist. If you're using IP from somewhere else, you're going to want to document that. Any questions before we jump into this? So how do you protect your copyrights? Again, real simple, copyright ownership, assignment agreements with employees and contractors. I mentioned you can do all these things before you get to a lawyer. You can find these sort of documents online. I'm sure amongst this entire room, some of you may have signed contractor agreements in the past, so pulling those out of your files and seeing if they'll work for the present. Educating staff or educating each other on the importance of your copyrights and IP. So what do I mean by that? All of the big startups that have gone on to become prominent and make a lot of money, really most of their value is in their intellectual property. This isn't 1920 where the value of a company is based on having the biggest factories or things like that. It's going to be your intellectual property that's going to make your company really attractive to investors or shareholders. Include a copyright notice on all significant original works. That's software, manuals, advertisements. So I saw some of you generating some look like publicity materials. That's the type of thing that you can certainly put that copyright notice on. Protecting trademarks. Before you select a name, and I know you're all doing this on the quick and kind of picking names between Friday and Sunday. So make sure that you pop that name into Google. Just make sure no one else out there is using it. You can go to the USPTO database and do a quick search there if you know how. It's not too difficult. I recommend using website NameCheck. Pretty easy. Pop in a word. I did sponsor proof, which I think is one of the groups here. This tells you, on all of these different platforms, whether that account has already been taken. You see something like this, and it's pretty widely available. I'm guessing you guys may have already grabbed that Facebook. That gives you a good indicator that this name is going to be available. So it's super easy. So use a trademark notice, similar to that copyright notice. You don't have to have a trademark registration in order to be using your trademark notice. In fact, I recommend that you start using the TM as soon as you start putting your trademark out there on the internet, because that's considered in commerce. And if you intend to protect that name, let the public know that. So what does that look like? This little TM, this is Serve Creatively's logo. I don't know if they're going to roll with this, but this is what it could look like. Pop a TM on there and let it run. Grab your domain names. First and foremost, everyone in this room probably understands that. It wasn't a common practice in the 90s, but nowadays, people are pretty savvy about that. If you find that your domain name's already taken, that's a good indicator that you need to do a little deeper research and see how the name is being used. protecting your patents. So the patent, actually obtaining a patent registration is a lengthy and expensive process. It's something you definitely want to talk to a patent attorney about. But before that, you can be doing things like making sure all your employees, contractors enter into assignment, non-disclosure, and non-compete agreements. Again, these are pretty standard agreements in the industry, so you know, if you may already have one in your form files, or you can contact an attorney, and they'll be able to get you these at probably little to no cost, unless you're having them do much work there. Require all technical or inventive personnel to keep dated notebooks, logs of inventions. So you guys are doing a lot of hard work here in the next, well, yesterday and today and tomorrow. But documenting when things are created, it doesn't seem terribly important at the time, but it can become important down the road when you actually do go to protect your patents. Require invention disclosure forms. You know, that may be once you get to a little bigger level and you start to lose track of what everyone's doing, but just making sure that that information gets documented at some point. Conducting a periodic legal and technical review of possible inventions. You know, obviously you're not going to be necessarily in a position to do a legal review, but just checking in from time to time and seeing whether something has been invented that potentially could be or should be protected. And then involve experienced patent counsel at least 3 months before using, selling, offering to sell, or publicizing inventions. So the trick here is that once you do any of these things, it starts a 1-year running timeline in which you can protect your patent. So if you start selling your invention and then wait 13 months, you've effectively cost yourself the ability to receive patent protection. And so what's the problem there? If you don't have patent protection or trademark or copyright protection, you're letting your competitors essentially come in and freely replicate what you've put all the hard time and effort into developing. When do you hire a lawyer? So, I heard this a couple years ago, similar to when do you hire a doctor. If you go too early, it can be painful. If you go too late, it can be deadly. So, do those things that I've mentioned. Keep a good idea on what you're doing with your IP, and then having an initial consultation with someone like myself is really just as easy as sending me an email and let me know you want to have 20, 30 minutes to talk. I don't usually charge for an initial consultation. I know a lot of attorneys don't. So sometimes it can be enough just to have that conversation and figure out, yeah, you don't need to do this right away. You can do it 6 months from now. You can do it a year from now. But just getting someone on your side from the beginning just to help steer you in the right path, and it can be a